For 60 years, one rule protected millions of immigrants chasing the American dream. In one move, the Trump administration just erased it. If you have a green card, are waiting for one, or know someone who is, the next few minutes could change everything you thought you knew about permanent residency in the United States. We're talking about a policy that has stood since 1965, a policy that shaped families, careers, and entire communities across America. Gone. Just like that. But here's what nobody's telling you. This isn't just about paperwork. This affects millions of people right now. Skilled workers who've spent decades in the backlog, families separated by bureaucratic limbo, entire industries that run on immigrant talent. And the ripple effects? They're already beginning. Will green card holders lose their status? What happens to pending applications? Are there legal challenges that could reverse this? And most importantly, what should you do right now to protect yourself or your loved ones? We've broken down every angle, the legal, the political, and the deeply human side of this seismic shift. Whether you're directly affected or just trying to understand what this means for the future of immigration in America, this video has the answers you need. This is one of the biggest immigration stories in a generation, and it's happening right now. If you believe people deserve to stay informed, smash that like button before we dive in. Let's get into it. Let's start at the very beginning, because to understand why this matters so deeply, you need to understand what this policy actually was and why it's been the backbone of American immigration for over 6 decades. Back in 1965, the United States passed the Immigration and Nationality Act, also known as the Hart-Celler Act. Before that law, immigration to America was governed by a system heavily skewed in favor of Northern and Western European countries. It was openly discriminatory, tied to national origin quotas that essentially said certain nationalities were more welcome than others. The 1965 Act changed all of that. It shifted the priority from where you were born to who you are, your skills, your family connections, your contributions. It opened the door to millions of immigrants from Asia, Latin America, Africa, and beyond, reshaping the very fabric of American society in the process. And one of the most important protections embedded in that system was a principle of fairness in green card distribution. Every country, regardless of its size, was given an equal cap on the number of green cards it could receive per year. The idea was simple: no single country should dominate the line. Everyone gets a fair shot. That rule, combined with a first-come, first-served application process, became the foundation of how America managed legal permanent residency for 60 years. Now that foundation has been shaken. The Trump administration has moved to restructure how green cards are allocated and prioritized, effectively dismantling the per-country cap system and introducing a merit-based framework that critics argue will create new winners and new losers in ways that are both dramatic and deeply unfair. For those at the front of the line, this might sound like great news. But for the tens of millions of people waiting behind them, the story is very, very different. Here's where this gets personal. Because we're not talking about abstract policy changes. We're talking about real people whose lives are being reshuffled without their consent. The biggest losers in this new system are immigrants from high-demand countries, specifically India and China. Why? Because under the old per-country cap system, even though these countries sent enormous numbers of applicants, they were still capped at the same rate as smaller countries. The wait times were already excruciating. We're talking decades for some Indian-born workers in the employment-based green card backlog. Some estimates suggest that Indian nationals already in the system could wait over 100 years to receive a green card under the old rules. Yes, you read that right. Over a century. With the new policy changes, the dynamics of the backlog shift in unpredictable ways. On one hand, removing per-country caps sounds like it could speed things up for those at the front of the line from high-demand countries. But it simultaneously creates new uncertainty for applicants from smaller countries who previously benefited from proportional access. The carefully constructed balance of the immigration system is now being tipped, and nobody is quite sure where the scales will land. But it doesn't stop there. The administration's changes also affect the family-based immigration system, which has long been a cornerstone of how immigrants reunite with their loved ones in America. The new framework de-emphasizes family ties and doubles down on employment-based criteria. What this means in plain language is that your relationship to an American citizen or green card holder matters less than it used to. What matters more is whether you have a degree, a job offer, or a specific skill set that checks the right boxes. For families already separated by borders and bureaucracy, that shift cuts deep. Of course, a change this significant doesn't happen without a fight. And that fight is happening right now in courtrooms across America. Immigration attorneys, advocacy groups, and Democratic lawmakers have already begun mounting legal challenges to the new policy. Their argument is multifaceted, but at its core comes down to this. The executive branch does not have unlimited authority to unilaterally rewrite immigration law. Congress established the framework. Congress set the rules. And altering those rules in such a sweeping way without legislative approval, critics argue, oversteps the bounds of executive power. This is not a novel argument. We've seen versions of this legal battle play out before with DACA, with travel bans, with temporary protected status decisions. And the outcomes have been mixed. Some executive actions have survived court scrutiny, others have been struck down, sometimes partially, sometimes entirely. The legal landscape around immigration powers is complicated, and it shifts depending on which courts hear the cases, how the challenges are framed, and ultimately how the Supreme Court interprets the extent of executive authority. What makes this particular battle especially interesting is the political timing. With a conservative majority on the Supreme Court and a White House determined to push through its immigration agenda as aggressively as possible, the legal path forward is genuinely uncertain. Advocacy groups are preparing for a long fight. Some experts believe injunctions could pause the policy changes while litigation unfolds. Others think the administration has structured the changes carefully enough to withstand immediate legal challenges. The truth is, nobody knows exactly how this plays out in the courts. And that uncertainty itself is devastating for the millions of people trying to plan their futures. Let's talk about something that often gets overlooked in the immigration debate. The economic consequences. Because this isn't just a human rights story. It's a business story. It's a technology story. It's a story about whether America remains a place where the best and brightest from around the world want to build their lives and their careers. Silicon Valley has been sounding the alarm for years about the broken green card system. Companies like Google, Microsoft, Amazon, and hundreds of smaller tech firms have a massive stake in how green card policy plays out. They employ thousands of highly skilled workers on H-1B visas, people who are waiting in the exact backlogs we've been talking about. For these workers, the green card isn't just a piece of paper. It's the difference between building a life in America or eventually being forced to leave, taking their skills and their innovations somewhere else. The business community largely wants reform, but the kind of reform they're looking for is faster processing, expanded caps, and streamlined pathways, not a wholesale restructuring that creates new layers of uncertainty. When workers don't know if their immigration status is stable, they make different decisions. They decline promotions. They avoid buying homes. They consider job offers in Canada or Australia or Germany, countries that have been actively recruiting the exact talent that American immigration policy is pushing away. The irony is profound. At a time when America is in an intense competition with China and other nations for technological supremacy, the immigration changes could accelerate a brain drain that plays directly into the hands of America's rivals. This is a point that some Republican business leaders have made quietly behind closed doors, even as they publicly support the administration's broader immigration agenda. Beyond the policy, beyond the politics, beyond the economics, there are human beings at the center of this story. And their stories deserve to be heard. Consider the Indian software engineer who came to America on a student visa 15 years ago. He earned his degree, got a job at a major tech company, filed for his green card, and has been waiting ever since. He's married to an American citizen. His children were born here. This is the only country his kids have ever known. and yet his legal status remains in a kind of permanent limbo, subject to policy changes, subject to employer sponsorship, subject to rules that can shift overnight. For him, this latest change isn't an abstraction. It's another chapter in a story that has already consumed the better part of his adult life. Or consider the Filipino nurse who came to America to work in healthcare, drawn by recruitment programs that the American hospital system built specifically to fill critical shortages. She's been working through a pandemic, caring for patients who wouldn't otherwise have been cared for, waiting for her green card application to be processed. Under the new policy framework, her pathway to permanent residency looks different than it did when she made the decision to come here. The rules changed after she was already here, already invested, already committed. These aren't edge cases. These are the stories of millions of people who made life-altering decisions based on a set of rules that have now been changed beneath them. And no matter how you feel about immigration policy broadly, there is something worth pausing on in that reality. The human cost of policy instability, of promises implied if not always explicitly made, and of a system that asks people to commit everything and then changes the terms of the deal. If you or someone you love is in the immigration system right now, the question at the top of your mind is probably the most practical one. What do I actually do? And while we want to be careful here because immigration law is complex and every case is different, there are some general steps that experts across the board are recommending. First, and most importantly, speak to a qualified immigration attorney as soon as possible, not a notario, not a paralegal, a licensed immigration attorney who practices specifically in the areas of your case. The legal landscape is shifting rapidly, and having professional guidance tailored to your specific situation is irreplaceable right now. Many legal aid organizations also offer free or low-cost consultations for people who can't afford private attorneys, and that's worth looking into immediately. Second, document everything. Make sure your paperwork is complete, organized, and accessible. If you have pending applications, know exactly where they stand in the process. Know your priority date. Know your case numbers. Know the exact terms of your current visa status. In times of policy uncertainty,